Good evening everyone, my name is Harshita Singh. I'm a legal intern in LEXIS and Company. Today my video presentation topic is a valid adoption. So, adoption means legally binding a child to his new guardian. In Rame Subhya versus Chanchu Ramya, the term adoption was defined as a judicial act creating a certain relationship between two strangers, purely civil, paternity and affiliation. Under this act, only a Hindu can adopt a Hindu child. Section 5 of the act states that adoption is to be regulated by this chapter. This chapter means chapter 2. Section 6 and section 11 together provide the requirement for a valid adoption. So, for a valid adoption, the person adopting has the capacity and also has the right to take in adoption. The person giving in adoption has the capacity to do so. The person adopted is capable of being taken in adoption, and the adoption is made in compliance with the other condition. Here, other conditions are mentioned in section 11 of the Act. If adopting a son, the adoptive father or mother must not have a Hindu son, son's son, or son's son's son. If adopting of a daughter, they must not have a Hindu daughter or son's daughter. If the person is adopting a child of the opposite sex, then the age difference must be 21 years. The same child may not be adopted simultaneously by two or more people. The child to be adopted must be given and taken in adoption by the parents or guardian concerned, or in the case of an abandoned child or a child whose parentage is not known from the place or family where it has been brought up to the family of his adoption. Performance of datta homam shall not be essential for a valid adoption. Section 7 and Section 8 talks about the capacity of a male Hindu to take in adoption and female Hindu to take in adoption. Here, the consent of the wife is important, but the wife should not be a minor or of unsound mind. And the consent of husband is also necessary, but he should not be a minor or of unsound mind. After amendment of Personal Law Act 2010, female has got equal rights relating to adoption. Consent of wife is mandatory. The consent should be in writing or by a positive affirmative act done by her voluntary. Her presence alone at the adoption ceremony cannot be considered as her consent. This was said in the case of Ghisalal versus Dhapubai AIR 2011. Section 9 talks about the person capable of giving in adoption. Father or mother could give for adoption with consent of the other. If the father and mother are incompetent to give in for the adoption, the guardian may give in adoption even to himself with permission of the court. Section 10 talks about the person who may be adopted. He or she is a Hindu. He or she has not already been adopted. She has not been married, or in case if customs allows the marriage, adoption after marriage, it can be done. Or she has not completed the age of 15 years. And section 15 talks about cancellation. It says that a valid adoption cannot be cancelled. Okay, thank you.